My name is Joe Hadzima, and this is a presentation about the legal forms of doing business in the United States. That is, the organizational structures, corporations, partnerships, etc., and the options you have and the implications for all of these. The themes we're going to talk about today include liability, economics, and what I'll call pigeonhole or preventative law. This pigeonhole concept is we have a set of facts, and if it comes to characterizing something, which of the various boxes would this go into? Sometimes called pigeonholes. The image on the right is a rural post office in Vermont. So theme one, liability. Here we're talking about the liability of owners of the business versus individual liability. The important point here is that a person is always liable for his or her own acts or omissions. So if you come to me and say, I want to set up a corporation because I've invented something and I want the patent to be in the corporation, so I'm not liable, the answer is wrong. You are liable for your own actions. So if you have a defective product, people could come after you, regardless of whether it's in a corporation or not. We also want to ask, when can a person be liable for the acts or omissions of another? Classic case here is the principal-agent relationship. So if I'm the principal and I appoint you my agent, I'm going to be liable for the things you do as agent in the course of the engagement, within the scope of the engagement. And that's called principal-agent liability. A variation on that is vicarious liability. An employer and an employee, for example. So if I'm Federal Express and you're a driver, an employee driving a FedEx truck, and you have an accident, not only will you be liable potentially, but I as FedEx would be liable. Again, if it's within the scope of the employment. If you go and rob a bank with your FedEx truck, probably not liability on the part of FedEx. Now there is other ways in which you can be liable, and that is through legislation, statutory liability. For example, the Securities and Exchange Commission imposes, and the acts that are the securities laws impose liability on the part of directors of public companies for misstatements or omissions to state information about the company. That's statutory liability. Now, it's important to recognize that the legislative process is not global optimization. So, for example, let's say we have a legislative effort in the area of occupational safety and health that led to the formation of OSHA, the Occupational Safety and Health Administration. We also have legislation that prohibits discrimination. That's the Equal Opportunities legislation. These two might come together. In a classic case was at a battery manufacturing facility in which, lead-acid batteries, in which the employer, because of concerns about OSHA, said that women of childbearing age could not work on the factory floor because of the potential exposure to lead and what that might mean for their babies. And therefore, they would have to work in administrative positions. Now, the fact was that people working on the factory floor made more money than those working in the office. And a suit was brought on the part of women in the company that said, look, you're discriminating on the basis of gender. You can't do that. And so you're the employer. You've got these two different legislative mandates. How do you reconcile these? That's left to you. The legislative process only put these two mandates on you. So something to keep in mind as you're managing a business, how do you take care of those two things? Now, when we talk about liability, it's also informative to think about creditors. You're liable to someone, that person is a creditor of yours. So if I borrow money from you, I'm the debtor, you're the creditor. That's a voluntary kind of transaction. But if you happen to walk up the front steps of my building and you slip and fall because maybe I haven't cleared the steps off from ice, you're an involuntary creditor because you may have a right to recover for my negligence in not maintaining the building. You didn't intend to be a creditor, you're an involuntary creditor. So for voluntary creditors, you can contractually, in most cases, limit liability as a contractual matter. For involuntary creditors, it's hard to do because you don't have a contract with the involuntary creditor. This is where things like insurance come along to provide you with protection from liability. So our first theme is liability. And does it matter what form of organization we have? What are the liability implications? Our second theme is economics. The choice of the entity, the way in which you do business, has economic consequences. And it's primarily through the taxation of profit and losses and gains. Here we're talking about layers of taxation and whether the entity passes through the tax liability to the owners instead of having it at the entity level. And we'll see how that works. The economics of the business, the financeability of the business is also a function of the choice of entity, as we'll talk about. The third theme is preventative law. In litigation, the person suing has to convince the fact finder that the facts are so that a desired outcome is achieved. Muster a case that because of this, this, and this, therefore this outcome. In the preventative law world, we try to create the proper structure so the facts as envisioned will give the desired outcome. In other words, if we're careful in how we set up the entity, if we operate it appropriately, then it would be hard for, in litigation, for somebody to argue that it's something other than what we intended. And so that's taking the facts and putting them into the appropriate pigeonhole. So let's start with that. We're going to look at various forms of doing business, and we're going to look at liability. Again, liability of the owners, taxation. How are the economics of the entity taxed? Control. Who has a right to control or not control? Whether ownership interest in the entity is transferable, and by that also leads to whether it's a financing vehicle, and then looking at things like the cost and complexity of setting up that entity. So the simplest form is called a sole proprietor. This is unlimited liability on the part of the owner. So let's say I decide back when I was in business school, that I would like to. There wasn't coffee available anywhere near class, so I decided to set up a little cart in the lobby where I sell coffee. Now I may need approval from the health authorities and others to do that, but in terms of my ability to operate as a sole proprietor, I don't need permission to do that. So I have unlimited liability because I'm acting as myself. There's one layer of taxation. I take whatever profit or loss comes out of my little coffee cart and I report it on Schedule C of my federal tax return. Control, yeah, I mean, I'm it, just me. Transferable, sure, I can sell the whole thing to someone else. Not really a financing vehicle in its own right because it doesn't have any independent assets. It's all part of me. So I might need to provide guarantees and other things for loans. And the cost and complexity is minimal. If I'm not doing business under my own name, if I set it up and call it Joe's Java cart, that's an assumed name or a fictitious name, and I might have to file something with the city or the state to notify creditors of who I am. So pretty straightforward. It's just me. Now, suppose you come along and you say, you know, I've been talking to people and I'm a pretty good baker. I think I could make money if we sell some muffins alongside the coffee. And I say, sure. And what we've just done is formed a general partnership if we don't do anything more. General partnerships are defined under state law in the United States, and there is a uniform Uniform Partnership Act, which has been adopted mostly in the same form by every state. And it says that a general partnership is one or more persons engaged in business for profit. And so that's what it is. Without more, the two of us are there. We have a general partnership. We don't need any written agreement. It's there. Now the problem with that is the liability is not only unlimited, it's joint and several. The picture you see here is a partner's desk. These were popular in investment banks and merchant banks, where those were run as general partnerships. And because you and I are going to be jointly liable for anything that happens, and severally, meaning individually, the two partners would face each other and keep an eye on each other. Because if I do something wrong, you can be jointly liable with me, and even though you've done nothing wrong. So you can picture from a investment viewpoint, this is not a good thing for people who would want to invest in a company. Control, a general partnership is a pass-through entity. That means that the profit or loss of the partnership there's no tax return for the partnership. Those attributes get passed through to the partners in accordance with either an agreement they have or by default under the Uniform Partnership Act. Control, yes, we in theory both have the ability to control, but only with respect to matters that were in the scope of what the partnership was about. The transferability is limited because if I try to transfer an interest in the partnership, it dissolves the partnership, and a new partnership would have to be formed to the person who stepped into my shoes. And for that reason, it's a limited financing vehicle. And the costs and complexity can be minimal. But because the defaults may not be what you intend from a business viewpoint, you may incur and want to probably incur expense in writing an agreement that sets forth what the economic relationship and control relationships are among the general partners. So it doesn't matter what we agree between partners when it comes to liability. It's somebody injured by activities of the partnership can go after the individual partners jointly and severally. It's just how we settle up among ourselves. Well, as you can see, that again is not a very good vehicle to raise money if you're need to raise capital. So along comes something called a limited partnership. Now, this is a limited partnership has two classes of partners. a general partner or partners who have unlimited liability and joint and several liability, and the limited partners who have limited liability. They're only liable for the amount of money they've invested, plus the amount of money that they've taken out of the business. The taxation is passed through the same way as for general partnership. The control of the limiteds, the trade-off for being a limited partner is you can't have active control of the business, otherwise you'll be characterized as a general partner. So it's typical that a partnership agreement would provide what's called negative control. It says that the partnership or the general partners can do these following things. If they want to do something else, they need approval from the limited. So that's sort of a negative control. It's telling the partnership and partners what they can't do. Transferability is limited, same issue. If you transfer limited partnership interests, it may dissolve the partnership or may require approval. As a financing vehicle, it is an improvement in that now I may be willing to put money into the business as a limited partner, knowing that I'm not going to put all of my assets at risk. And the cost and complexity, again, if we don't do anything, it's straightforward, but most of the time, the default rules are not what we would intend, because especially for startup companies, there's typically a service provider, that would be you, the entrepreneur, and a capital provider, me, the person putting money in. And the default rules under the Uniform Partnership Act is that ownership is dependent on, is based on capital. And since I have most of the capital that were put in, I would end up owning most of it, which would not be something you'd want. So we have to have an agreement that would talk about who owns what and how that's all going to be divvied up. Now, it's important to note, let's go back to this pass-through. What's being passed through is our tax attributes, revenue, expenses, etc. It doesn't mean that cash is distributed. Those are two separate things. Your agreement may provide that cash distributions are made to enable the partners to pay the taxes on their own income tax things, but it's not a given. You have to provide for that. Now, an example of a limited partnership is venture capital funds. Most are organized as limited partnerships. They're the general partners. These are the venture capitalists, the people you will deal with as an entrepreneur. They may have been entrepreneurs in their own right in a prior life, or they might just be financial types. And they form a fund, a venture capital fund, and they put together an offering memorandum, and they go out and they raise money from limited partners. These would be everything from pension funds, educational endowments, foundations, insurance companies, wealthy individuals. And they pitched it saying, hey, we have expertise in whatever, and we're raising a fund. Would you like to invest? And if in fact they convince enough people that they have met their minimum fund size, they'll have a closing, which is closing up of the fund means that the offering has stopped and nobody else can get in. It doesn't mean, however, that any money is actually put in yet. There may be some minimal money going in. And that's where we get to the economics of venture capital. So if I, as a limited partner, commit to invest $10 million in your fund, you're the general partner in the fund, that's my capital commitment. Now, I don't want to give that money to you right up front, because what are you going to do with it? You're going to put it in the bank? I mean, I can manage my own money. What I'll do, though, is when you make a capital call, when you say, here's an investment that we want to make from the fund in this new company, your proportionate amount is, we need 100,000 from you. and 100,000 from all the other $10 million investors. Those are called capital calls, and that's when money actually goes in. And it's at that point that the stopwatch, so to speak, runs on calculating what the return on the investment is. And this is an important metric for the venture capitalists to show that they have superior returns to other venture capitalists. So how does the economic work with respect to the fund? Well, first thing is the general partners receive an annual management fee, which is usually a percentage of the capital commitments to the fund. Typical is 2.5%, so that means on a $400 million fund, the management fee would be $10 million a year. It's used by the general partners to run the business, rent, pay salaries of the general partners, support staff, etc. Now, when you think about the number of the size of the fund, because the partners in a fund have fiduciary responsibilities, especially if they're taking on pension money, they have to oversee the investments. And there's only so many investments that a single person can oversee. And so that defines maybe the size of the fund. So a $500 million fund might have 5 general partners, each of whom is given the responsibility of investing, $100 million of the fund's capital. It doesn't mean each actually invests that, but that's sort of the, ballpark metrics. So this is important when you're thinking about venture capital. If you only need $1 million and the business doesn't require a lot of capital to scale, you're probably not going to be that much of an interest to the fund, the venture capital fund, because they've got to deploy and manage a lot more money than $1 million. So what happens? The money goes into the capital calls made, money's invested in your company. You go ahead and execute on your plan. Maybe there's another round of financing, whatever, and now it comes time to harvest the investment. Now, these funds are typically 10 years in length, the first 3 years of which are making initial investments. The middle, after a few years, there may be a company or two acquired or went public. And then there may be some other rounds in the middle years, and in the last few years, they're winding up the fund. So how does the economics work for the limited partners? Well, the limited partners typically receive 99% of all of the returns from the investment in your company. So let's say the fund puts a total of 10 million into your company, and it's sold for $100 million. And at the end of the day, the fund's portion of that 100 million sales price is $40 million. Well, the first 10 million that comes out, 99% of that goes to the limited partners and 1% to the general partners. And that continues until the limiteds have received back their initial $10 million. In some cases, there's accrued interest on it, so that is an additional amount. Once the limited partners have been paid back their portion, then the split goes 80% to the limiteds and 20% to the generals. This is called the general partners' carried interest. And has been subject to a whole bunch of discussion about whether it should be taxed as ordinary income or capital gains. Currently, it's capital gains as of 2022. Now, this structure works out pretty well because it says the investors are putting money in because it's as part of their overall investment strategy. They can buy stocks themselves or bonds. This is called an alternative investment class, where they're looking for outsized returns, which means that the general partners have to aim to make 5 to 10 times the money in order to get good returns for the limiteds. And this 20% carried interest gives them a lot of incentive to, strike it big, because they're going to get 20% of that upside. Now, as I said, the typical deal is 20% carried interest and management fee of 2.5%. Very successful funds might be able to negotiate better fees, 3% management fee and maybe a 30% carried interest. Very few do that, but typical is 80-20 and 2.5%. So that's an example of an entity, a limited partnership, and how it works, the flexibility of allocating the economic returns, because the agreement's going to provide for these incentives, etc. Now, at the other extreme, we have sole proprietor partnerships. At the other extreme, we have a corporation. A corporation is, in the United States, except for certain banking corporations, are creatures of state law, just like partnerships. And these were set up as more capital was required during the Industrial Revolution. You can think of the Industrial Revolution. A sole proprietorship works fine if you're, the local miller of wheat in the village. And now, when money is needed as to buy equipment, etc., we need to amass more capital. We need to get people to invest. They don't want liability. So these companies or corporations are formed. And originally in the US, they would be by the act of the legislature on a case-by-case basis. Eventually, corporation laws were passed that said, if you follow these things, then you can set up a corporation yourself. You don't need legislative approval. So how does a general corporation work? Well, limited liability to the owners. If I put my money in, I'll buy the stock, company goes bankrupt, I'm not going to have my house isn't going to be at risk. The taxation typically is 2 layers. The corporation is treated as a legal entity that can be taxed. So there's a tax at the corporate level, and there's a tax when money is distributed to the shareholder. Control from the ownership viewpoint is limited. The shareholders elect the board of directors. The board of directors appoints the officers, and the board is tasked with overseeing operations on behalf of shareholders. Transferability generally is yes, subject to the securities laws, but you can sell shares and stock in compliance with the securities law. It becomes a nice financing vehicle because now you've been able to amass more capital, and so the company itself has more, can have more stability. And the cost and complexity is pretty straightforward. There are incorporation fees, there are annual filing fees, etc. But it's sort of reasonable. Now, just an important factor on limited liability is, in order to maintain that limited liability, you actually have to follow corporate formalities, operate in accordance with the statute. If you don't, the courts may step forward and, quote, pierce the corporate veil. This would happen if you mingled company money with your personal money, you didn't sign contracts with in your name as an officer of the company on behalf of the company. If you failed to file the periodic reports, etc., they could come in and make an argument that you're not really acting as a corporation, so we shouldn't treat it as such. So you want to make sure that you follow that type of all those requirements. Now, wouldn't it be nice if we could avoid 2 layers of tax? Wouldn't it be nice if we could pass through stuff to shareholders and still have the corporate form? Well, that's what's called an S Corp. A C Corp and an S Corp. These C and S are subchapters of the Federal Internal Revenue Code. If you do nothing and set up a corporation under state law, let's say Delaware or Massachusetts, whatever, and do nothing else, you're going to be taxed as a C Corp. If you qualify and elect, you can be treated for tax purposes as an S Corp. And in order to do that, you have to have 100 or fewer shareholders. Those shareholders have to be mostly human beings. They can be certain types of trusts. They have to be US citizens or permanent residents. There can only be one class of stock. And profit and loss is allocated on a percentage stock basis. So the economic allocations are a little more rigid compared to the limited partnership, where we can flip things around as in the venture capital fund. But if you do that, then you get the benefits of the ease of a corporate form with some of the tax benefits and liability protection of a corporate form, and the tax benefits of partnerships. This has sometimes been called the S corporations are sort of incorporated partnerships, they say. Now, let's look at subchapter S, taxation. Most startups have losses. We raise money, we're investing in product or services, we're losing money. Why do I care? It's not going to be taxed, right? It's just going to be losses. Well, the real issue is because of the exit. That is, if a startup is acquired, often it's acquired for cash. And if the company has very little in the way of assets, other than the software or whatever, then the purchase price for the company, the cash paid minus the basis, as they call it, in the assets, which are essentially what was invested, that spread is capital gains. And it's going to be taxed at the corporate level, because that's where the gains were. And then when you turn around and distribute the funds to the shareholders, there'll be another tax. So here's an example of how that works. Based on 2014, in this case, rates. So C corporation, net profit before tax is 100,000. Corporate tax rate of 35% means there's 65,000 of that 100,000. Now we distribute that 65 to shareholders. Individual tax rate close to 40%. So the net cash to the owners is around 40,000, an effective tax rate of 61% almost. In an S corp, no tax at the corporate level. The attributes are distributed out to the investors, and they pay 39,600 in taxes, so they get net cash of 60,400, or a rate of about 40%. So you can see the savings, the potential savings there in the event of a sale of the company, which is one of the reasons it's been popular. Now, just historically, you have to look at individual tax rate. This chart shows over time the highest individual income tax rates. Sometimes you would rather keep the money in the corporation because the corporate rates are lower, but in most cases, the ability to avoid the two-layer of tax pays off. So, are there other forms of doing business? Well, there is something called the limited liability company, LLC. Very much like a partnership, but with more flexibility, can act a little bit more like corporations. One of the advantages of a corporate form when it comes to startups is if you're going to provide equity, stock, and stock options to employees, very straightforward in a corporate form. Harder in a limited liability company, can be done, but it's a lot more complex. But the LLC could have, does not have the constraints of the type of shareholders. So you can have two corporations could get together and be members of an LLC, or you can have a foreign investor. You can have more than 100. So more flexibility in an LLC. And then in between is something called an LLP, Limited Liability Partnership. This is typically something that's used by professional services firms like accounting firms or law firms. And one of the, who otherwise would have been general partnerships, And the advantage of an LLP is that it can limit the liability of the individual partners in terms of the joint liability. So in an LLP, I think you might be liable up to $500,000 or something for as in a law firm in Massachusetts. That's why you'll see a number of, as opposed to unlimited liability. So that's sort of your main menu of entities. Relatively recent things are benefit corporations. A benefit corporation or B corporation designed for nonprofit entities that wish to consider society and environmental issues. In addition, designed for for-profit entities who want to take a broader view than just the return to shareholders. And there are statutes that have been passed now in 35 states for benefit corporations. So what did we discuss today? We've looked at liability of owners, and the impact on the ability to raise money for your venture. We've talked about entities as it relates to the economics, what it means to owners of the business. And we've talked a little bit about pigeonhole and preventative law in the sense that we want to structure, if we want to be a limited partnership, for example, we have to make sure that we don't provide direct control for a limited partner. We have to provide a different way of them to constrain what can be done with their money. And if we're a corporation, for example, we do have to make sure that we're abiding by corporate formalities. So that's the preventative law part. So I hope you find this brief introduction to forms of legal entities for businesses helpful. There's a lot more detail, of course, around each of these, but hopefully you get a feeling for the pluses and minuses of both at the high level, and you'll be able to discuss the particulars with your lawyer when the time comes to start a company.